Welcome back to the deep dive. Today, we're getting into the world of commercial contracts.
And a really crucial part of it, performance.
Exactly. We're asking what happens when a seller delivers something that's almost perfect. Maybe even better than what was ordered, but it's not technically what the contract says.
Well, this is where you see a huge shift from older common law to the modern Uniform Commercial Code, the UCC.
How so?
Under common law, you had this perfect tender rule. Any tiny flaw could be a fatal breach.
So no room for error.
None. But in modern commerce, especially with goods, it just needs more practicality. So Article 2 of the UCC, it aims to protect sellers who are making honest efforts. And Section 2508 is really the key. It's the shield that lets them fix their mistakes.
Okay, let's unpack that shield. Our mission today is to dissect this right to cure a defect. And we're going to focus on the toughest spot for a seller when the buyer rejects the goods and the contract delivery deadline has already passed.
That's the one. We're zeroing in on UCC 2508, subsection 2. It's the part of the rule designed to protect a commercially honest seller from what we call a surprise rejection.
A surprise rejection, you mean when a buyer is just looking for an out?
Precisely.
Yeah.
Maybe the market price has dropped and they want to escape the deal. So this deep dive is all about the strict requirements a seller has to meet to get more time after that original deadline is gone.
All right, so before we see it in action, what's the core rule? The black letter law for the right to cure after the deadline.
Okay, so you have to look at the general rule of UCC 25082. This section basically says that if the seller had a legitimate, reasonable reason to think the buyer would accept the first delivery.
Even though it wasn't perfect.
Right. Maybe it was an upgrade or just had a tiny flaw. The law says they should get a second chance, even after the contract time is up.
But there have to be conditions.
Oh, absolutely. The rule allows the seller to substitute a conforming tender, but only if 3 distinct elements are met. First, the seller must have had reasonable grounds to believe the non-conforming goods would be accepted.
Okay.
Second, they have to seasonably notify the buyer that they intend to cure.
And third?
And third, they have to make a substitute conforming tender within a further reasonable time.
That first element, reasonable grounds to believe, that feels like the real commercial heartbeat of the rule.
It is. It stops sellers from being punished for acting in good faith.
Let's see how this actually plays out. We're going to dive into the facts of a really key case, Bartus v. Riccardi.
A classic. Let's do it.
Let's analyze Bartus v. Riccardi. First, what are the legally dispositive facts? What actually happened here?
So Frank Riccardi, he consulted an audiologist, and then he contracted with a seller named Bartus to buy a very specific hearing aid, a model A660.
Okay, a specific model.
Very specific. But when Bartus delivered it, he didn't bring the A660. Instead, he delivered a model A665.
And what was that?
He told Riccardi it was a newer, improved version. So Riccardi tries it for about 15 hours, complains about some noise, and then, critically, he realizes it's not the model he ordered.
And he rejects it.
He rejects it and returns it. Bartus immediately offers to replace it, either with another A665 or the original A660. But Riccardi refuses everything. He just wants out of the deal. So Bartus sues him for the money.
So what's the core legal issue for the court? Is Riccardi's rejection the final word, or can the seller force the deal back on track?
That's it exactly. The precise legal question was whether Bartus made a proper subsequent conforming tender under UCC 25082 and basically cured the defect after Riccardi had already rejected the goods.
And what rule of law did the court apply here? Can you state the full rule and break it down into its testable elements for us?
Sure. The court went straight to UCC 25082. The rule lets a seller substitute a conforming tender after a buyer's rejection, even if the time for performance has expired. But to do that, the seller has to prove 3 required elements.
What are they?
1, the seller had reasonable grounds to believe the non-conforming tender would be acceptable. 2, the seller seasonably notifies the buyer of the intent to cure. And 3, the seller makes a substitute conforming tender within a further reasonable time.
Thank you. That gives us a clear roadmap. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that crucial first element, reasonable grounds to believe?
Well, the sub-issue here is pretty interesting. It's whether delivering a technically different but superior product is enough justification.
An upgrade, basically.
Exactly. And the court found that because the model A665 was explicitly called a newer and improved version of the A660, the seller did have reasonable grounds to believe Riccardi would accept it.
So providing an upgrade is strong evidence of good faith.
It's a very strong case for it. It shows the seller wasn't being negligent or trying to pull a fast one. The law wants to protect that kind of honest mistake.
Understood. The improvement provided the justification. Now, what about the second element, seasonable notification? Did Bartus act quickly enough?
So the sub-issue here is just about the timeline. Seasonably doesn't mean instantly. It means acting within a reasonable time for that kind of transaction.
And did he?
The court said yes. Bartus immediately told his company about the complaint, and they sent a letter confirming the offer to replace the aid with the correct A660 model. Because it happened so quickly after the rejection, the court found it was within a reasonable time. It met the standard.
So the buyer isn't left hanging.
Right.
And finally, what about the third element? Did the seller actually make a substitute conforming tender? Did he put his money where his mouth is?
The court looked at two things here. First, was the new offer actually conforming? And yes, Bartus offered the exact model A660 from the contract, so that's a check.
Okay, and the second thing?
Second, had the buyer's position changed in a material way? And in this case, Riccardi hadn't gone out and bought another hearing aid. His situation was the same. So the offer to supply the correct model counted as a proper tender.
Wait a second, let me just challenge this from Riccardi's perspective. He ordered a specific medical device, probably based on clinical advice.
True.
So isn't forcing him to accept an improved model and then forcing him to stay in the contract a bit much? Shouldn't the court have been stricter with the seller who messed up the order in the first place?
And that is the classic tension that the UCC is built to resolve.
Yeah.
Technically, yes, Riccardi had the right to reject the A665 under the perfect tender rule.
Okay.
But the moment he did, the UCC 2508 cure provision kicked in to protect the seller. The UCC really limits that power of rejection when the seller can fix the problem quickly and without harming the buyer.
So because Bartus immediately offered the correct model.
The court basically decided that letting Riccardi walk away would be opportunistic. It would just be letting him use a minor good faith mistake to get out of a contract he didn't want anymore.
Yeah, that makes the policy very clear. So after analyzing all those elements, what was the court's final conclusion?
The court's ultimate holding was for the plaintiff, for Bartus. Because the seller satisfied all three of those rigorous elements, reasonable belief from the upgrade, seasonable notice, and a proper conforming offer, the seller successfully cured the defect.
And the buyer lost his right to just walk away.
Exactly. The contract was back on.
So that reasonable grounds to believe is the real gatekeeper. It separates an honest mistake from trying to sell someone inferior goods.
It's everything.
Let's make this totally unforgettable. Let's try two contrasting hypotheticals.
I'm ready.
Scenario 1. A buyer contracts for 1,000 pounds of grade A coffee beans at $5 a pound. The seller accidentally delivers 1,000 pounds of grade A plus coffee, which is usually $7 a pound. He thinks the buyer will be thrilled.
A free upgrade.
Right. But then the coffee market crashes overnight. The price plummets to $2 a pound. The buyer immediately rejects the A plus beans as non-conforming. Does the seller have reasonable grounds to cure?
Yes.
Yeah.
Absolutely. This is almost a textbook case. Just like in Bartus, delivering a demonstrably superior product creates a very powerful presumption of reasonable grounds.
The market price change doesn't matter.
Not for this element. The analysis focuses on the seller's intent and the quality of the goods. They weren't trying to cheat. So, yes, the seller can cure by delivering the standard grade A beans, and the buyer can't use this technicality to escape a bad deal.
Okay, now let's contrast that dramatically. What if the buyer orders 1,000 pounds of grade A coffee, but the seller delivers 1,000 pounds of grade B beans? They're clearly inferior, they taste awful, and just labels them as grade A. Does the seller have reasonable grounds to believe that delivery would be accepted?
No, almost certainly not. The seller knows the goods are substandard. This isn't an honest mistake. It's fundamentally lacking in commercial honesty.
Unless there was some kind of prior history?
Right. Unless there's some very unusual course of dealing where the buyer has accepted grade B in the past, maybe with a big discount. But barring that, no. The protection from UCC 25082 is for sellers who make honest errors, not for those who knowingly try to pass off junk.
That distinction really locks in the policy. It's protection for honest effort, not for bad faith.
Precisely.
So could you synthesize all of this for us? Give us an actionable checklist for analyzing a seller's right to cure under UCC 2508.
I can. If you're faced with this issue, here is the step-by-step framework. First, you always start with a scope check.
Is it a sale of goods?
Is it a sale of goods governed by the UCC? If yes, you're in the right place. Second, check the buyer action. Did the buyer actually reject the goods because they were non-conforming?
Okay.
Third, and this is critical, is the timing check. You have to figure out if the rejection happened before the contract deadline. If it did, you apply 2501, which is simpler. The seller just has to notify and deliver the right goods before the deadline.
But if it's after the deadline, like in Bartus?
Then you must go to the rigorous UCC 25082 three-part test.
Got it.
So fourth is the 25082 diagnostic. The seller has to prove all three elements. A, do they have reasonable grounds to believe the goods would be accepted? Look for an upgrade, a minor defect, something that shows good faith.
Right.
B, do they seasonably notify the buyer? Check the timeline. And C, did they make a substitute conforming tender within a reasonable time?
And has the buyer's position changed?
Have the buyer's position remained unchanged? Exactly.
Yeah.
And then fifth, finally, your conclusion. If the seller meets all three of those elements, their cure is effective. The buyer's rejection is invalidated, and the seller wins.
That framework is incredibly powerful. It really shows how the UCC shifts the risk away from that old, strict, common law idea of perfect tender.
It does. It moves toward a more commercially sustainable system where you're encouraged to fix your mistakes, not just terminate the contract. It protects the seller from losing a whole deal over a curable good faith error.
So the seller's right to cure is a strong default rule.
It's very strong. But that leads me to the final provocative thought for you to consider.
Okay.
If you're a buyer and you're in a high-stakes deal where timing and exact specifications are absolutely critical, say a specific part for a product launch, you can't just rely on the UCC's default compromise.
So what do?
You have to ask yourself, how could you, as a sophisticated party, contract around the seller's right to cure? What specific language would you need to write into that contract to get rid of Section 2508 and force that old strict performance standard back into play? That's really the essence of allocating risk when you're drafting a contract.